right. Hey, good evening and welcome to the Wednesday, December 10th meeting of the Dudley Planning Board. At this time, I would like to remind everyone that this meeting is being recorded and ask everyone to rise and join us in the Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Okay. Oh, all right. And just note that Mr. Chinaki has joined the meeting. And start with new business. Approval of minutes for November 12th, 2025. Does anybody have any?
Mr. Chairman, I would move that we accept the minutes, November 12th, 2025, as presented, and compliment Brady. He's got a pretty good record of what happened here.
Okay, all right. We have a motion. I have a second.
Second.
All right. All those in favor? Aye. Opposed? Unanimous? All right, item number 2, request for certificate of completion, Sophie's Way, Sawmill Road LLC, Representative Attorney Howard Potash. At this time, I will recuse myself from the proceedings.
That's me.
Really had time to warm it.
Good evening, Mr. Chairman. Howard Potash, I represent Sawmill Road LLC, and tonight we seek certification of the subdivision as complete. I have a memorandum, if I could give copies to you.
Yeah, sure. Mr. Chairman, do we need him to sign it? Front of the sign-in sheet?
So went out there.
Brady might have some.
Yeah, we know his name. Brady, do we have a sign-in sheet in case anyone else comes?
I did not grab one. Actually, I think I have it in my card over there, so I'll grab that.
Thank you. And I have with me tonight also the engineer, Zach Bless, if you have any questions from the engineer. And I try to outline briefly the issues, and we feel that, and should be approved. I attached the declaration of access and utility easement, some pictures, and the work by existing grade, and I believe that the peer review engineer, Mr. Walsh, has written a very appropriate opinion on the matter. So we would respectfully ask that the subdivision be certified as complete, the lots are sold, and that the board vote. And we ask that the a small amount of money that's left as a bond be voted to be released.
So you feel that your client doesn't have to come up with this rainwater recharge system?
Our position is that he shouldn't have to do it because the lot owners have the lots have been sold, and all of them have been sold. I think 3 of the houses are built, 4th one is built, and all the lots are sold, and it's a private way. There's a private way maintenance agreement. That would be our position. The one neighbor that had some problem with some runoff. We understand he is now satisfied that there is not a problem. All the houses will have or will have gutters, and so we feel, and we would ask that respectfully, that we should not have to do any further work.
And were these lots sold before the decision was made for the subdivision?
I'm not exactly sure. I wasn't involved until recently, but I know all the lots have been sold and building permits issued for the houses. And my understanding is that all the people who bought the lots are very happy and satisfied with the lots, and that they have no problem whatsoever.
Right, but there is that one owner that's only within 500 feet of the place that was complaining. He said that the neighbor's yard was under 2 feet of water for 2 weeks.
Well, I
This was
understand.
during rainstorms. We haven't had that much rain since then.
I understand in the spring when there was a lot of rain, he was unhappy, and now the situation is resolved. I had a water consultant take a look, Glenn Kavorsky, that I use all the time on water issues, and he took a preliminary review for me when I got hired, and he doesn't believe there's any problem or any work that needs to be done on it. In the spring, when there was a problem, there was a very excessive amount of rain, which is well beyond what is normal, but he doesn't see any problem. And this gentleman who had a problem, I believe my client checked with him, and he is satisfied. He has no complaints. If he did, we would assist him, but he is happy with the situation. He doesn't have any problem at all with runoff, and the gutters should even if there's a heavy rains, the gutters should solve the problem. And if he does have a problem in the future, we're gonna assist him to solve it. But there is no problem at the moment to solve.
Do you have that in writing?
Yeah.
Would you be willing to put that in writing?
Oh, I think we would put it in writing that if there's a problem, we would assist them. Sure.
And did your client inform the buyers of these lots that they would have to comply with this? What's it called? The
Well, they
roof
did-
recharge system?
They did sign the utility easement private way maintenance agreement.
That's a little bit different, though.
They all signed it as part of the purchase, and my understanding is that none of them have any problems whatsoever. They're happy with the houses they built, and I think there's one to be complete, and they're very happy with their purchase, what they paid for it, and the area and the subdivision, and they have absolutely no problem. They're very pleased with what they did and what they own.
Okay, so the people that build the houses are pleased, you're saying?
My client informs me that he's has no negative feedback from any of these people.
Well, it wouldn't be them complaining, it'd be the butters that would be complaining. But I see actually a purchaser right behind you that joined that joined us, Bill LePage. Do you want to agree with that?
Sure.
Wherever you're comfortable, man, you know the drill.
Hi, Bill LePage, 4 Sophie's Way. So the rain event he was talking about in the spring, at that point, the rain gardens were completed, which caused the runoff to go into that abutter's yard.
All right, but they
Or completed,
they were
because I took
complaining.
pictures of
Can
it.
I finish?
Go ahead.
They were completed. Immediately after the abutters came in to the meeting, because I was here, Steve had landscaper come and finish the rain gardens.
They redid the rain gardens, from what the
They weren't
butter was saying.
completed.
Right, but the
So-
butter's saying that they resilted it, was what he was, Zachary Glass brought him out into the hallway and explained it to him.
Right, I was
We
I was
asked
standing
him
right there with
to
them.
Have him explain it to us. He
Yeah.
brought,
I'd like, I can clarify it again to the board. if you'd
I
like
would,
me to come
I
up.
would, I would
Yeah.
like, but after, not yet, not yet, not yet.
So the backup, the rain gardens weren't 100% complete, which caused the water runoff to go into the abutters yard. I was out in the hall with him when he was explaining to them. Immediately after that, Steve had his landscaper come in and finish the rain gardens. They redug them out, dug them deeper, put in the mulch, put in the plantings. Since then, I mean, I live there, I keep an eye on it. I'm on boards in town, I'm a building inspector, so I keep an eye on stuff. I live in that neighborhood, and there's been zero problems since the rain gardens were corrected.
Yeah, but when I took pictures, the rain gardens were overflowing and they were finished. All nice mulch, trees, everything. I think it's still in there. Is it still in here, pictures? Well, you seen me drive down your road that day.
Yeah,
See the runoff going into the neighbor's yard.
there was
You can see all the mulch going down.
there was some runoff from my neighbor to the left because his yard wasn't completed. The grading wasn't done. Since,
Yeah, but that front one was, as soon as you pull in that detention pond, well, that thing was overflowing all over the road and all over the neighbor's road.
I didn't see that, and I lived
I
there,
took
so.
some pictures of it. I'm not lying, I took pictures of it, I sent it to the board, the rain gardens were completed, they were overflowing like crazy.
They were, I don't know if that was before or after, but, go ahead, Richard.
Yeah,
That was
Mr.
right
Chairman,
before the
if
meeting,
I may,
last meeting.
thank you. Mr. LePage, perhaps. Reference in here in the documentation we were provided by the attorney, there's a post-construction stormwater operations and maintenance plan. Are you familiar with that?
Yes,
You are. And
Yeah.
it says further that post-construction stormwater operations and maintenance packet be provided to all current and future owners of the property as well as all responsible parties to ensure maintenance and inspection requirements contained herein are made fully aware and understood.
yeah, that was all included in our closing
Okay,
documents.
so there is a plan going forward in terms of maintaining the property as
Oh.
it should
And
be.
you 5 lots will be
All right, I think the
maintaining it.
question needs to be answered before you,
We need to, now that, well, once you guys release the subdivision, then me and my neighbors obviously have to get together and come up with a plan.
Oh, so that happens after it's,
Yes.
after it's released?
Yeah,
I thought that was already in effect.
Yeah.
it's,
That's what
it's,
this guy was
Yeah,
telling us,
that's,
it was already
that's
in
what
effect.
Steve said. It
it's
was
in the
already effect.
deed that the homeowners are responsible.
Right.
As far as coming up with a plan, like how we're gonna pay for it, how we wanna do it, we haven't done that yet.
I thought that was before, like,
No.
every winter it says it right in the plan, I thought.
No,
Maybe that was the covenant I'm thinking of, but.
maybe.
So you have a
All the-
copy?
All the abutters are aware that we're responsible for the plowing and the maintenance of the rain gardens.
Did he ask you to get a roof recharge system?
Yes,
Well-
Steve told me that right from the get-go, and
Was it in writing? Do you have a,
I don't recall, but I think it's in the deed.
I believe it's in the deed, subject
Yeah.
to
the maintenance agreement?
the
Yes.
maintenance
Yeah,
agreement
yeah.
is referenced in the deed, which is the normal way of doing it.
Yeah, I did put a
And it
recharge
ru-
in
it
mine.
runs,
The recharge system
runs
is
with the
not.
land, so if someone sells, the buyer is bound by the terms that are in the deed. That's the usual way of doing it.
That's the maintenance agreement you're talking about, correct?
I'm sorry?
That's the maintenance agreement? Not, we're talking about the roof recharge system.
Yeah, it would be, if it's referenced in the deed, then it runs with the land, and it's, any subsequent buyer would be bound by it.
Do we have a copy of that, Braden?
Have the deed copies?
No, not the deed, the maintenance agreement.
It was included in your emails, I'm not sure.
Yeah, I know it was included in the emails. I just don't remember seeing a roof recharge system in the.
Maintenance agreement wouldn't have anything to do with a recharge system.
That's what I'm asking. Did your client provide every buyer a copy of this drainage thing that they're required to do for this
I
subdivision?
wasn't involved, but my understanding, each buyer of each lot was provided with all the full documentation, and they all agreed before they bought the property. That was part of the transaction.
Yeah, I know when I went to my closing, it was verbally read to us. Because then the question came up, well, do we have to create an HOA? How do we do this? Blah, blah, blah. You know, because I came from Florida, and we had HOAs where,
Well, originally it was an HOA when there was a covenant involved.
Yeah.
But then the covenant disappeared. And
yeah, so I think it's just
The
up
HOA disappeared
to
too.
the owners now, you know.
It was, originally there was an HOA, Mr. Wetruba, and then you changed it to a maintenance agreement
Yeah, so
right
I don't know
before.
if you got the
Right
old
before.
copies.
I've watched all these meetings recently. Braden, do we have a copy of this, what Mr. Clark was talking about, the post-construction stormwater operations maintenance plan?
I think that might be it. I think it's,
That's in my,
turn a few more pages, having
the one that
seen all the
Mr.
meetings, I'm
Kotesh
sure
gave
you've
us.
read all the pages.
Right, but
Page 7, halfway through.
page 7. Page 7's my third.
I think I included the plans and some pictures and, of the lots, so you would have a complete picture of all the documents that I
What was
have.
referring to
I
is
included
number
in,
7.
with the
I don't know
memorandum.
What it sits on in terms of the front end. It looks like it might be somewhat, there's a 6, there's a 4, there's a 5.
So do we have proof, I guess, I mean, I know Bill says he had it. Do we have proof that everyone got this post-maintenance agreement plan?
My understanding that everyone got that, and was explained to them at the closing. I don't think there's any doubt about that, and I assume they were all, I wasn't involved, but I assume they all were represented by a lawyer when they made the purchase, who had all those documents and reviewed it with them.
I have doubt, because I had the chairman of this board telling us that we misremember him coming before us with the maintenance agreement, which he never did. And I've watched, like I said, I watched every single meeting. I've not seen any maintenance agreement. There's mention of one, for sure. He's told us that he was gonna bring one, and we have one now.
Well, he said
And
the
that was
board
Tom's
voted on
concern
it.
originally, when you guys were coming to release the surety, partially release the surety. So,
I know I've had verbal conversations with the neighbors, and we're all aware, so, I mean, I can't speak for them.
More
if
about
you're,
the guy's
well,
yard
if you,
one.
I guess my concern.
I'm sure
is
he'd be here if there was an issue.
If
Yeah,
you're,
but then you're
if,
liable for it. You realize that.
if they're all aware that they were supposed to come up with this this roof recharge system, why don't we have any of them? Do you have one for your house?
Yeah,
Could you give it to Braden?
excuse me?
Could you give it to Braden?
A recharge system?
The roof
Want me to go
recharge
dig up
system
my
says they
yard?
were supposed to apply for the roof recharge system.
I have pictures of the one I put in. Is that what you mean?
I don't know. It says they were supposed to be getting plans. Developers are how does it say? Lot developers, but if the lot developers don't know about this, this is a subdivision-specific condition, number 1.
I don't think there's any evidence whatsoever that the unit owners, the lot owners know about it, and there's no complaints whatsoever, and they were fully made aware, and the road is going to be continued as a private way. I don't see any problem, and we will request in behalf of Sawmill Road LLC that the certification of complete of the subdivision be allowed tonight. I don't think there's any reason not to do so. If the lot owners had a problem, we certainly, and my client would have certainly been there. I would have him comment, except that I understand you have a rule that when you just recuse yourself, you can't participate at all in the meeting, so I don't want him violating your rules.
No, that's not a rule. All subdevelopment owners come and speak to us.
One last comment from me. regardless if the owners receive this, is it irrelevant? I'm the only one that bought a lot and built my own house. The other ones were
This is
built by builders.
unconventional drainage for this subdivision, so yeah, it's kind of part of it. That's what Graves Engineering said that.
No, you're asking if all of the owners have a copy of that.
Have a copy of what?
If I read that and I didn't know better, I wouldn't even know what I was reading. It's irrelevant because they bought the houses.
Subdivision-specific standards you're talking about? The
No,
conditions?
I'm saying, you're asking if the owners have copies of the recharge system requirement.
Right. Well, I'm asking.
They didn't build the houses.
Well,
they probably
okay,
don't
I'm
know
asking
what
if,
it is.
That's what I'm trying to say.
well,
I can
if they were informed.
Could you explain that to him, because he doesn't understand?
What don't I understand?
Somebody signed a contract, didn't even know what a recharge system was.
Right, I understand that.
And the
but
homeowner isn't responsible to
It's
put
on
it
the onus of the
in.
developer here that came to us and created these specific conditions.
Mm-hmm.
We didn't come up with this. This was agreed upon by
Yeah.
by Steve.
All I can say is I know he told me,
Okay?
like, when I was building my house, make sure you do your recharge system, and I did it,
Okay.
so. Any other questions for me?
How many
no,
houses,
nothing.
how many houses
Thanks,
are
Bill.
totally built and finished there? Right now, 4
4,
out of the 5.
4 out of the 5.
And 1 out of the 4 has the recharge system, the other 3 don't.
I can't answer that, I don't know.
The
Brayden?
other- The
Brayden?
other three lots were bought by builders, and they built houses and then sold them off.
Correct.
So we have no, for clarity, we have no recharge systems at all for any of the 4 houses?
I have not seen any plans for recharge systems.
Okay. That's number 1 on the special specific, or subdivision-specific conditions.
Well, I think it's the obligation of the lot owner who built the house to put in the system, not the developer.
But if he doesn't know about it, then how is it on him?
I think they know about it. I think that's a
Okay,
fair, they bought it, I assume most of them have mortgages. They were represented by an attorney when they bought these things, a real estate attorney who would have seen the documents. So again, I would respectfully ask in behalf of my client, Sawmill Road LLC, that the subdivision be certified as complete. I think it's appropriate that it be complete, and I don't believe there's any reason to delay doing it. The town had a peer review by Jeff Walsh, who is a very qualified fellow from Graves Engineering, and he issued a report that the project is completed. And I attached that to the memo as Exhibit B. So I think there is no, I will respectfully suggest to the board, there is no reason to deny it. And I would ask that the board tonight move to approve it. And I think my client, as a matter of law, is entitled to certification that the subdivision is complete, and there's no evidence, respectfully, there's no evidence before you that it should be delayed. And so he has asked me to ask you to vote on it tonight. I suppose you have a choice to approve it or not approve it, and I believe that as a matter of law, he's entitled to approval because and the evidence is that the peer review from Graves Engineering, who does a lot of peer review, has provided that the project is completed, and that's Exhibit B. So that would be our position tonight. If you want to hear from Mr. Gless, I'm sure he'd be glad to, who did a lot of work here, he'd be glad to expand on what I've said. If you want, Mr. Gless?
Come on.
Existing grade ink, that it should be, it should be approved, it should be approved tonight.
Mr. Gless,
Yes, sir.
you were at the meeting when Mr. Billis was here complaining about the runoff. So would you agree with Mr. Potash that there are no complaints?
There's been no complaints since that has been remediated. And
At that meeting,
oh, go ahead, sorry.
at that meeting, you and our assistant planner were in agreement that it's a runoff from a house. There's a runoff from the house that was making all the water damage, I guess.
Who is the assistant planner?
Eve Tapper. She was saying that it's a neighbor
Not the assistant
dispute.
planner, she was the planner of record.
Yeah, she said it wasn't coming from the subdevelopment, it was coming
I
from
didn't
the
say, did I say
houses.
assistant? I didn't mean to say assistant.
Oh,
I
I
said
think you
assistant.
misspoke, but that's all right. Go right ahead.
So again, so if I could clarify on kind of the discussion that we had about those rain gardens, and that incident came up during construction of the subdivision and the lots. And as I'd stated before, that those rain gardens got silted up due to runoff from the lots during construction because they hadn't been stabilized. There was no grass planted yet that hadn't grown in. So now that the subdivision has been completed, we're not getting all those silts and fines that are running off any of these lots during construction to plug up those rain gardens. And those rain gardens are designed to hold water and then infiltrate. And they hold water so that the plants that have been put in there, that they thrive in that environment, so they actually help, kind of suck up some of that water. So the incident that happened at the beginning of the spring was again due to construction on these lots, that the silts and fines had run into those, plugged them up, and since then they've been remediated by removing all of those, I don't want to say contaminated soils, because that's putting too much emphasis on what it is, but removing the kind of the plugged up sand that's at the bottom of those things, replacing it, and then putting the mulch down. And now that the site is stabilized and all the grass is grown in, we're not getting that runoff going into those, or I should say, not getting those fines getting, washed into them, per se.
And you watch these rain gardens get remediated? Were you there when they dug them up, or is that just,
Well, I mean, I could ask the landscaper, but I mean, I know that the process was
so
the,
you see them digging that up?
I did.
yeah, they scraped out all the top stuff, because that stuff gets plugged up, and then that sand, yeah, it's,
I lived there and I knew we were gonna be responsible, so I was watching.
Because when I took pictures of that, that thing was flowing into the neighbor's yard down,
Through the chair, if I may, Mr. Janaki, when were these pictures taken?
you got them in your email.
I got them in the email. That was some time ago then, some time ago.
The day
Some time ago, right?
before-
Some weeks
no,
ago?
hold on. The day before that guy complained, that rainstorm, the next,
Okay.
that meeting.
All right, I'm
I went
looking at a
down there.
report here dated October 29, 2025. Whatever you provided was long before that, correct? And indicated in there, this is a report from
It didn't
Graves
rain.
Engineering. Doesn't look like there's any issues that I identify.
How
in
much
terms
rain
of
did
this.
we get this summer?
I mean, you took a look at something at a state in which it was in process, right?
No, it was finished.
It was finished.
completed.
Well, no, I think it's finished now.
I
That's what
know.
we're talking about here.
I don't know if this is gonna flood come spring again.
I don't know if this building could be washed away come spring again.
Well, I don't want-
Noah's out building an ark in the parking lot right now.
Well, go help them.
Maybe we should continue this
I
this
think we
spring,
should,
Mr.
yeah. Grab a
Clark.
bunch
Yeah.
of bales and let's go.
Most towns would continue for 4 seasons
All right,
and make sure
let
it doesn't flood.
me just cut to the chase, to the chair. What is it that you're looking for before you think this should be approved? What do you feel is missing? Obviously, there's a great
number
crime
one-
that's been
number
committed
one
here.
of
We
this-
wanna get the
Come
detail.
spring, and if it don't
Mr.
flood,
Janaki,
then-
if you will, the question was to the chair.
Subdivision specific conditions, number one. I want the roof recharge systems of every house, or I want an affidavit stating that it was given.
You want that from each of the owners? Is
I
that
want-
what you're looking for? You want each of the
I would
owners
like
come in
to
here
know
and
that
swear-
each of the owners
swear-
are
swear
aware.
on Holy Bible that they have this in their possession and are fully aware and going forward with it. Is that what you're looking for?
If, they don't have to do it on the Holy Bible, but
Well, okay, well, we'll use the Quran or whatever suits your purpose.
Could I just ask the engineer, did you do the design work for the drainage for this whole subdivision?
we did it for the roadway and the rain gardens as they were intended for the roadway runoff.
Okay, and on your drainage calculations for the rain garden, were the rain gardens sufficient to handle the runoff from the development without these recharge systems being put in, or was it based on the recharge systems plus the rain gardens making it all?
So when we did our subcatchment area for all the, and the subcatchment is the analysis they used for the overall site that drains to each one of these. We took the roadway, the shoulders, and then we put a factor of safety in for the amount of water coming in. But the lots themselves were not accounted for post-design into each one of those rain gardens. And that had to have been done because each one of these lots was going to be sold. So we could not anticipate the size of the houses that were going to be built, the nature where they were going to go. So these rain gardens were designed to kind of handle what was to be coming in for the roadway. By how much, I can't speak on that with certainty, but there is always a factor of safety put into these designs, as every engineer has to do these.
All right, Mr. Clark, to answer your question, photos were taken July 10th,
July, okay, there's a little distance between
Well-
July and October, but that's okay.
and that's July, that's not even April or May. And look, they're all completed. If you wanna
Nor is
see
it
them.
October.
Look, they're all flooded.
Thank you.
Deal
Mr.
guy, huh?
One
One
off.
other question to Mr. Potash. Earlier in the conversation, you said that your client would be willing to put in writing that if there was an issue with the runoff to an abutter in the future, that he would.
Can I just talk to him a second?
Yeah, way we're not screwing everyone that lives on that road.
No, I'm worried about the abutters again, not the people that live on the
Well,
road.
the butters and, like, Mr. LePage, we have to figure out a way to fix this in the end.
Yeah, that's the problem. You should be concerned about everybody, not just that
Yeah.
It's true.
Where we're
You
going.
guys are responsible, Bill.
Mr. Bless, do you have any idea what a water recharge system would cost for a typical house?
I'd try to stay away from the install costs of those, but
Can you explain to us what one is while these guys
Yeah, go
communicate?
ahead.
Yep, go for it. Or do you need to go with them?
if you don't mind, I may excuse myself just to make sure. But then I can answer whatever questions you'd have.
Basically, what I've seen in the past for these things is basically they dig a hole at the end of each house, each corner of the house.
It's
where
like a
they-
cistern, right?
Yeah, and they just they can be plastic or they can be concrete. They drop them in, they fill it with crushed stone, they put a fabric around it so that it doesn't get
Yeah,
filled up
pretty
with silt.
much. You can't dump water off your property onto a neighbor's property
Right,
without
but you
going
can-
into a,
You can put it into basically a underground cistern, and then it basically
can-
recharges the aquifer when it trickles down into the
you can
ground.
dig a hole. put
If
crushed
these guys
stone
don't
and
know
pipe
that
in
they have to
there.
put that in, then
Right, but I mean,
That's
like,
on the
I don't
developer.
think it's like $10,000 to put one of these things in.
No, not even close.
That's-
You dig a
Actually,
hole, you get
Conrad-
a truck full of crushed
Conrad was
stone and
saying
a
it's
pipe.
expensive.
Yeah, I
I've
think
done it
it's-
on a couple houses.
I think it's a couple
because the
$1,000 at
neighbors
the most, so.
were complaining too. And did we get a sewage as built from this? Sewage, everybody clear on this?
I have plans here.
yeah. Did they provide the sewage as built?
So I don't know anything about sewage as built, I just have what he's provided here today.
So just to refresh everyone, Mr. Clark brought forward in June,
I've never seen that, no.
last June, 2024, a progress as built. Remember? The need for a progress as built in our
Yes, there was an
subdivision
issue
control laws.
pertaining to that. We didn't
And you
get-
said that these guys didn't need it because they were already in, but they were the only subdivision.
I had to refresh my memory, Mr. Durgan, but I don't think that's an accurate representation of what I
Yeah,
said.
you were arguing, Mr.
All right, well, no, wait a minute. You know, we have a conversation going, we don't need a third-party involvement. So let's try and keep it limited.
Rocks and that.
There was an issue, yes.
Okay, relax.
I'm not relaxed, I am relaxed.
Rocks and that.
Go ahead, go ahead, go ahead. Go on. I know what you're doing. It's as obvious as the nose on your face.
Mr. Clark, go ahead. What am I doing?
You are gonna
the
delay
record.
this, you're gonna drag this
I'm not
out as
delaying
long as you
anything,
can.
Mr. Clark.
And
It-
as
Well,
much
who
as you
cares? This
can,
guy neighbors,
you're
you
gonna
barking
see
and
that
flood.
this
I'm gonna really
night,
care
that
less,
nothing
so.
happens in terms of Mr. Wetruba receiving any additional money.
I mean, we had. all
This
I
is
can
on
say
record,
is
Mr. Clark.
We had a complaint.
You're gonna say this on record?
Yeah, we had a complaint,
That-
and now
that
I'm
I think
worried.
is
He
almost
came
as
back in
clear
and
as
said
the
everything
weather
was okay.
Outside.
It is pretty clear.
Yeah, but
Yeah,
it
it
says
is.
We can't-
it didn't
Admit it.
actually
Thank
rain.
you.
That was
Admit it.
taken in July 10th.
That was 5 months ago.
Yeah, with no rain all summer.
I also seem to remember on August 13th where Guy Horn, you told me my vote didn't count. Richard agreed with you. And then Mr. Wetruba went and cashed that check, so.
But how did that hurt the town of
Mr.
Dudley?
Clark wants to continue to
We were
make
working on an
accusations, we'll do
assumption
that.
that something was in fact a valid vote at the time, Mr. Durgan, and I don't recall that your objection was particularly noted at that point. You seemed to pretty much roll over with that one.
Hi, Mr. Chairman, I can give you our answer. My client is unwilling to agree in writing, because it's not his responsibility with the purchases to put in a recharge system, and it's not his obligation to do so, and so he's not and no one who bought the lots is asking for that. They know it's their responsibility. There is no present problem, and we would respectfully ask the board to vote on the certification of the subdivision, and obviously you could vote to approve it or deny it, and if it's denied, we feel that that would be improper under the law, and we would respectfully appeal your denial to the Massachusetts Land Court and ask the Land Court to set aside your denial. And I say that with great respect for the board, but we feel that enough time has gone by. This was discussed, my client tells me, in August, and we ask that the board rule tonight, one way or the other, and we will act accordingly. We hope that you will approve it, but we want a vote tonight, and we're prepared to do what is necessary to protect my client's rights under the law, and we don't feel that the board would be correct in denying the certification based upon the facts tonight. And I would also point out the lots have been sold. My client doesn't have the right to go onto someone else's property. He's not the owner anymore. He wouldn't have any right whatsoever. He would be a trespasser, and he has no right to go and dig up anyone's yard or do anything. At this point, he would be liable and be a trespasser. He doesn't have the right to do that. So with all great respect, I ask the board to vote tonight on the motion to certify the subdivision as complete and to release, I think there's a small amount of money remaining on the bond, some $4,700, somewhere in that amount. And I would point out that peer review, Mr. Walsh has approved it, and I don't believe there's any credible evidence, anyone that says that it shouldn't be released. So I believe that it would be improper, with all due respect, to deny it, and my client would be forced to exercise his rights under the law. Thank you. I would ask you to vote on this tonight.
What was your client's responsibility to inform everybody who he sold the lots to?
I'm sorry?
It was your client's responsibility to inform everybody on that road.
I think he has. I don't think there's any
Oh,
evidence.
you were saying he had.
You know, I
If you
don't.
brought me all the details, I'll be like, all right, he informed
You
them,
know,
and there would be no question here.
With all due respect, I believe that he's met his burden under the law. We've given you all the documents, and I believe, and I say this with all due respect, I've been a lawyer for 52 years, and I believe that if you deny the certification, that the Massachusetts Land Court, we would have a right to go to the Superior Court or the Land Court.
You have the right to
I believe the Land Court would issue an order and a judgment reversing your denial. And that's my advice to my client, to seek a vote tonight, and hopefully you will approve it. If you deny it, we'll file an appeal to the Land Court and file for summary judgment with based upon the facts that are there tonight. There is no evidence whatsoever that it should not be. It should be not certified. And if it was delayed, there isn't going to be anything different than is there tonight. It just is. Would be inappropriate to deny, to certify the subdivision for lots of sold. So I would ask respectfully that the board, and I respect what you've said, but I would ask that the board vote accordingly. And we'll, and if denied, we'll seek our redress in the Massachusetts Land Court, which has jurisdiction.
Mr. Chairman, I would move that we,
Actually, Mr. Bliss, you're gonna inform us about the recharge systems?
I mean, I can answer any questions you have. I don't know.
Explain what a recharge system is for the board.
I mean, a recharge system as in the roof recharge systems. are more or less a dry well, which is a hole or kind of a chamber that gets buried in the ground that collects the water and infiltrates it where it is. I mean, there's 14 different ways you can do it, but in essence, it is something that collects runoff from impervious surfaces and forces it into the ground where it is.
Yeah, not into the neighbors though, because I've done one before that the neighbors complained. Just dug a hole for crushed stone and not really.
Okay.
Mr. Chairman, if I may, make a motion that we grant the certificate of completion for Sophie's Way.
We have a motion.
Second?
All those in favor? Any discussion? All those in favor?
Aye.
All those against?
Aye.
Nay. So motion failed, tie vote.
And may I respectfully ask that the board release the balance of the bond.
I'll accept the motion.
Mr. Chairman, I would make a motion.
Mr. Chairman, I might be mistaken, but you raised your hand.
I did raise my hand, but I didn't say aye.
Oh, okay.
I caught that too.
All right, if I may, I make a motion that we, for the reduction of the surety for Sophie's Way.
Second?
We have a motion and a second. All those in favor?
Aye.
Aye.
Nay. All those against?
Nay.
Nay.
So can you tell me what the vote is then, please?
The vote failed. 2-2.
How much?
2-2, the vote failed.
Well, the chairman cannot vote, so that would mean you're denying the motions. And I would.
We didn't deny anything. The motion failed based off of 2-2 tie.
Well, I would respectfully ask that you issue that vote, and we'll take our appeal to the appeals court. And I think, to the land court, I think the land court, if my experience would be, if it's a 2-2 vote and someone had to disqualify themselves because he's the petitioner, that they would order the matter referred to another town board by the town administrator, or take any other appropriate action. And I would respectfully suggest that I don't believe there is any basis to deny it, and I would ask the board to issue an appropriate order.
I would remind you that subdivision specific conditions, number 1, has not been met. Number 5, which is the post-construction stormwater operations maintenance packet, we don't know if it was ever delivered to.
I would respectfully disagree, and I would also refer to you that I did send a letter to the town administrator when I was hired, and my client feels that there's bias on the part of 2 members and prejudice against him, which violates his rights.
I can assure you, I have no cares about Mr. Otroba at all. I know you're talking about me, sir, so I'm going to tell you one thing. You mentioned August 13th. This guy took away my vote on August 13th, and Mr. Otroba came in and told our accounting team that the vote had passed, and that it was a 2-2 vote, and that it had passed, and that he had the majority of the vote.
I'm not here gonna argue, keep arguing. Let's move
No,
on.
no, I would just respond, there was a 2-2 vote, your town treasurer released it, and it's the decision of the town treasurer, and I'm going to ask the land court, with all due respect, to disqualify 2 members of the board who voted here on the basis of prejudice, and that I'm going to ask the town administrator to appoint temporary other members to hear this matter, because
What's
there
your
was
proof that
no
a-
doubt.
What evidence do you have,
And I
sir?
say this with great respect, there is no doubt that 2 members of this board are unfair, and it's a very unusual situation when the person you're voting
Okay, sir.
against
We welcome
is the
that.
chairman of this
We welcome
board.
that, sir. Thank you.
And I believe the
Thank you for your
town-
time, sir. We welcome your
Give
opinion.
me the chance of responding,
You already
sir.
have responded, sir. You threatened us with a lawsuit. I'm telling you, bye. Thank you.
And
Moving on.
Thank you very much.
Thank you, sir.
Thank you very much for showing me disrespect, sir.
You
And-
come here disrespecting me, and you're telling me that I'm showing you disrespect, sir? You're threatening a lawsuit right now.
I'm
You
gonna-
understand that, right?
I'm gonna
You're
ask the
threatening the
land
town with
court
a
to
lawsuit.
remove you from the board.
Okay, remove us.
And you know what? I believe you should consult with counsel because you may have personal liability
own
for
legal
your
counsel,
actions.
thank
And
you.
I'm gonna consult with my client whether we can sue you personally.
68
Thank you,
Eagle
sir.
Drive, sir.
I live at 70. I have my own legalized
And
counsel.
all I ask in all the years I've been a lawyer, that people conduct themselves, board members, and it's been rare that they have not been fair, but this is an unusual case where
Unfair?
the
You're flooding
petitioner
a
is the
neighbor's
chairman.
yard And he's saying that it's all set. Your client didn't meet the requirements. You got a neighbor's
Okay.
yard that's
Okay.
under water.
Thank you, sir. Thank you.
Thank you very much for hearing me. Thank you very much. Good night.
Thank you. Moving on. God. I guess I'll stick around, or is he coming back? For Sophie Mill, he already said it, sir.
All right. Back to the agenda.
All right, give me 1 second. Move my agenda back up here. Okay. All right, so now we're moving on to standard business. Discussion status report on finishing construction of and acceptance of uncompleted and / unaccepted subdivisions and streets, including Pierpont Estates, Country View Estates, Eisenhower Drive, Lyons Estates, Paul Lane and Circle Drive, Sophie's Way. So, I know we got nothing on Pierpont right now. Country View Estates, Eisenhower Drive, nothing yet there. Lyons Estates, nothing going on there. Correct me if I'm wrong, Braden, you can stop me on any of these.
I was right down.
Okay. We got nothing on Eisenhower, we got nothing on Country View Estates, and we got nothing on, which Eisenhower Drive, Pierpont Estates and Lyons Estates. So that-
Nothing on any of those.
Okay. Paul Lane and Circle Drive, we do have some news there. On Paul Lane and Circle Drive, Braden and I looked into it, and after that meeting, we went and looked in the binder for Paula Lane Circle Drive, right in the binder, right in the front. It wasn't in the binder, it was loose. There was a letter dated 2012, I think it was from Nancy Runkle to town council at the time. And basically, attached to that was a deed easement for drainage recorded in 2005. So the easement for the drainage pods on Lot 14, it's been recorded at the registry since 2005. So it's been there the whole time, and it's been on our binder the whole time. And, excuse me, and furthermore, I ran into Steve Sullivan, former planning board member.
Yep.
Day before Thanksgiving. And I asked him, and he told me that there actually was a test done where fire department, and Guy, maybe you recall this, fire department went there apparently and simulated a heavy rainstorm and to test these underground pods to make sure that the drainage was working. And he said, in his words, worked flawlessly. So,
You started to work flawlessly? I seem to remember a planning board meeting selectman meeting where Mr. Sullivan was saying differently.
I
That
think-
that the pods had been filled in.
I think the point
The point is, the planning board doesn't have the authority to override a court order. And the court order is a retention pond.
Well, either way, that's all gonna go back to court, so let's.
Exactly, and
It's gotta go back
it brings us to
and
the point I was laboring to make, which is it's an issue between the contractors for the two abutting projects. It's really not an issue for the planning board.
Well, the planning board's trying to approve it.
But the planning board isn't trying to approve anything. The planning board, we talked about a lot release, and we talked about why was the surety released as well, because if you look at the minutes of the meeting, it clearly stated that they were releasing the surety, except they were waiting for the easement, and the easement was then done and recorded.
Right.
in 2005. So once it was recorded,
I actually watch these meetings.
it's a fait accompli. It's done. The developer did what the board asked for at the time, which was record an easement for drainage onto that lot.
But he's still court ordered to put in a retention.
And then the argument that comes later that happened around the time when the betterments were attempting to be done, when they were trying to do a betterment for that road, they're actually talking about a completely different easement, where it's an access easement that has to do with that part of the road being a private way and that he had no right to have, and that's, the whole trespassing thing. And again, that's all, as far as I'm concerned, that's out of the purview of the board. If anybody wants to, I don't know, you want to keep this on here as a running, what are we going to do here, gentlemen? We're going to keep Paul Lane and Circle Drive on here
Let's ask
forever?
Nelson if he pulled the permit,
I thought you were taking
if he
it off.
dropped it or not.
We didn't need to talk about it until this guy comes in.
No, actually, Mr. Chinaki asked last time. He said, keep it on until we see if he gets a building permit, something to that.
Well, that was Nelson. He's like, do I give it to him or, because what he was
Right.
saying, planning board can't approve that law because it's
Okay.
a drainage easement.
So does somebody want to make a motion then to take it off of our list?
Well, let's ask
You're saying that
Nelson.
the easement's
because-
been granted. And it's approved by the planning
Yeah,
board.
did you get a copy of it?
We have the easement. I'm saying that the planning board doesn't have the authority to.
What
to
tab?
Accept that.
To be under standard business, I think the last page of it.
Okay.
I'm not saying there's not an easement, Stephen. I'm saying that the planning board doesn't have the authority to grant a different type of drainage. He had to tie into drainage.
Well, Mr. Durgan, I thought, my memory was that at the last meeting, you did say there was no easement. And actually, Braden actually
said-
recorded that there wasn't even
I
any
said
pause
that-
there.
that
And
there was no copy of the easement. We didn't have a copy. You just came up with it, man. What are you talking about?
I
You literally
couldn't,
just came up with it.
I couldn't have,
Braden, when did we get this easement? You emailed it to us last week.
Yeah,
where did I find that easement, Braden?
in the very first page of the Paul Lane binder.
Thank you.
So
You went through that binder so many times, I don't
looking for an
understand.
easement.
Okay.
Oh, God. This will be fun anyway.
So what are we doing? Anything? Nothing?
Reach out to Nelson and see if he dropped his permit request.
As far as I'm aware, he's not dropped anything.
He hasn't dropped anything, so we keep it on.
All right.
Can't really do anything.
All right. Inspections and actions associated with site plans, Legacy Landing Country Club Acres. We had a meeting up there with residents from the Country Club Acres and also with Jeff Walsh, peer review for the
I
town.
will step aside, Mr.
Oh,
Chairman.
yeah, and at this time, Mr. Clark is recusing himself. We walked the project and we listened to the residents, and there was also a representative there for Mr. Haynes. Mr. Haynes was not able to attend. He had a doctor's appointment. Anyways, he had a representative there, and the representative, I forgot his name, but.
Russ.
Russ, yeah, Russ was well-known by all of the people in the neighborhood, so. Anyways, we walked around, we listened to the concerns that they had, and Mr. Walsh took notes and took a lot of pictures, and he is in the process of generating a report. So I don't really think we need to discuss it any further until we get the results of that report.
Is it a final estimate report?
It's mainly to deal with, just to make sure the drainage is done correctly, and the main thing is to address the concerns of the abutters and the people that live there that have concerns about some areas where water's pooling where it's not draining correctly. And
If I may, Mr. Chairman, one of the big concerns that they have is ponding on a number of the properties.
right.
And there's some erosion to the walking path that's been put in place.
Mr.
So
Walsh is going to put together a recommendation.
Mr. Walsh took copious notes.
Exactly.
There's no doubt of that.
Right.
Did I get an invite to this walkthrough?
Everybody wasn't playing.
Did I miss it?
Yeah, sent an email because I needed to know, because if we had more than 2 members of the planning board present, we would have to have posted it. And I didn't get any responses.
Well, you could have technically had 3 if one of them was Mr. Clark and he recused himself.
I didn't want to.
Well, we had 3 before on Dan's Road. Me, Mark.
he probably posted it. I know we had three when we went to the wheat place.
Yeah, and it may have been posted. All right, moving along. SCP Solar Oxford Avenue, nothing there. Stevens Mill, nothing new. Solar project at the landfill, nothing there.
It's up and running. I sent you that email.
What?
The solar farm at the landfill.
That's right.
Yeah, there's a certificate of completion or whatever. Sent to John Ruda. None of us got it. But
Okay.
this is good. It's kind of our site plan. No, we should
Well, we
leave
can
it.
pick that one off if we have it.
They couldn't get it.
Oh, yeah, I don't know.
Do we have that?
Well, we don't have it. No, I sent it to Steve only.
And I don't recall getting it. I'm sure you did, but I don't recall.
Votes don't matter.
Dudley Housing Authority.
Thought we took this off.
I thought we
Why is
did
it still on the agenda? I forget.
Nelson hasn't issued the certificate of occupancy yet, so I kept it on here just in case.
Oh, okay. He's going to, though, right?
Yeah, I spoke with him. He should be getting around to that this week.
Okay, great. All right, so,
So could people be using that parking lot right now?
Oh, they're using
No
it.
certificate of
They're
certain.
using it.
That was all set except for the grass.
Yeah.
yeah, yeah.
We know
They've been using it all along.
Yeah, we know that it's done.
Okay, the accessory dwelling unit bylaw. So we got, Jane was still working on it remotely, and she basically put it together, and that is in, is that in?
It's under standard.
Standard business, yeah. So this is basically the final draft of the changes that are gonna be done to the, to our regulations. So they just want us to take one last look at it. So we sent this out to the whole board. So everything in pink is where the changes are being made.
Still trying to figure out which tab we're on.
Oh, under your blue tab, standard business.
I think the tab colors are different on every binder.
Really?
Oh. I'd be careful.
Oh, okay, so whichever tab is standard business in your,
And it looks like expected. I confess I don't see what I identify as such.
I need to print another one. I can do that.
you can have mine, I already read it.
All right, well, we can get your copy at some point, though, I think.
There you go.
Revised.
But it's,
All right.
yeah, so it's basically, it's everything we discussed in the past 2-3 meetings with the board regarding the ADU bylaw. And she also found some places where the language in our zoning would have to be changed just because it conflicted with the new ADU rules, so.
So this will have to go to town meeting?
I thought
No.
she was gone.
What?
I thought she was gone from
No,
that company.
no, she came back, like, right after that, I got notification that, no, she's still working on it for us remotely. She's physically not here, but in communication with the other gentleman from CRPC, and is staying with it till it's done, from what I gather. So the recommendation would be, to answer your question, no, it doesn't have to go to town meeting, we just have to have a public hearing,
Okay.
so.
Easier still.
Has to go to town meeting for the zoning part.
Mr. LePage?
Sir, I originally came tonight for the ADU thing. Bill LePage, 4 Sophie's Way. Was any guidance given on second ADU?
Yeah, by site plan review.
Okay,
Yeah.
So our thinking was, we'll do the one by right, because that's what the state's gonna force you to do anyways. And then you could do a second or even maybe a third, depending on site plan
on
review.
the slate, yeah.
So let
As long as
the,
you have your roof recharge system.
because we've got every,
I have pictures.
because we've got every, you know, everybody's got a different situation. You have somebody who has a
Yeah.
lot of extra space, or somebody who has a little.
So, is there a time frame on when somebody could apply for a second?
Right now, you can
Yeah,
apply
once-
any,
You can right now, or,
once the
okay.
law goes into effect.
or do you have to do the
Well,
public?
that's not right now, that's what he's asking.
Yeah.
State law's in effect.
For the
He's asking
ADU,
for a second
for
one,
a second ADU.
a second ADU. So for a second ADU, you have to wait until we adopt these bylaws, and we have to set a public meeting, which is what I was getting to.
There's no
Okay.
provision in the state bylaw for a second ADU?
No.
No, just one.
No,
Okay.
no, I don't, well, I didn't bring it tonight,
I thought
but
it
she,
was up to 3.
she gave us that package,
No, it's
that
just
packet,
one.
she explained what,
How many are you gonna get?
Many as I can.
I forgot what they call the by right one.
It's not for me.
By right, and then there's the,
People ask me
local
too.
ADU, which is
I
the
guess
local
it's a low
ADU
interest
bylaws where
rate
you can
if you do
add
that.
on extra
Yeah.
ones.
This,
But
the state's
Each-
actually coming out with
each
some pretty
locality
good
has
programs beginning of the year for the,
Right, didn't we cap it at
I was
3?
talking to her,
Yeah.
the one that wrote it, and they're gonna do communities
cap it at
now.
3.
yeah.
Small housing.
Yeah.
Special permit?
So you can have one.
What,
no,
four?
you're gonna
That's
be able
special
to
permit for
do
2 and 3, but
Crazy.
you couldn't,
So
you couldn't come back and ask for.
one by
4.
right, and then you can ask for a second, or maybe even a third,
Got one special permit?
but you can't ask for a fourth.
Just site plan review.
Right.
Good.
Let ZBA decide based on the lot situation, because everybody's situation is
Right,
different.
right. Right, thank you.
So, what are the board's, what's the board's pleasure? We set a public, could we set a public hearing for the January meeting?
Do we need that early?
Well-
Before it slides off our plate.
Yeah.
I mean, I think if we can get it done and implemented. We don't have to, I'm questioning what.
We have to go to a public
We
hearing.
have to go to a town meeting after
for
the
this.
public hearing. Like, the public hearing is to gather the information from the public, and then we make a recommendation to town meeting.
See, I thought these regulations we could change without,
But the zoning part. we can't
because of the
change.
zoning regulations?
Zoning, we can't change, that's what needs to go to town meeting.
Well, then that's all the more reason why we want to set the public hearing, get this out of the way, because if we have to ratify any of this
Saying
stuff.
Closer to town meeting.
Yeah, you gotta have a couple ones.
Because the next town meeting is May, right?
Yeah, I mean,
Yeah, so we could do it, we
you
could,
got 5 months.
well, you gotta give at least, what, 2 weeks notification in the newspaper for a public hearing, so,
Right, so we could still do it for January, but if you want to push it to February, I don't.
well, if we only, that's if we have 2 meetings in January. If we only
Yeah.
have 1 meeting in January, and it's.
I was just trying to stick to the timetable that CMRPC was trying to get us to do. They were trying to get us to get this all wrapped by the end of the year, and then they said, and then.
The end of this year?
Yeah.
I think.
Well, when we started this whole process, there was
May
a
have
thought we
May
could.
have thought, yeah.
In the fiscal year, it could
I
happen.
think we should try to do it for the first, if we continue having just 1 meeting and it's the first part of the month, it would be hard to do it in January and get your advertisements in. Because that's only like 3 weeks away.
Okay. Do February?
Yeah, do it in February, and then he's got plenty of time to advertise it.
First meeting in February.
Yeah.
Okay, which is, we got a new sheet
got
in
a
here with the new
schedule.
dates, yeah.
It's in here.
Oh, here's your sheet.
Send us the new business.
Oh, I did?
That's the other thing.
So that would be February 11th.
That's the other thing. The new one's in here.
Yeah, mine's like right after first page on standard business.
February 11th?
Yep.
All right.
February 11th.
So, somebody want to put that in the form of a motion, and we'll just approve it officially, that we're gonna,
Mr. Chairman, I'll make a motion that we hold a public hearing on the new town ADU bylaw on the February 11th, 2026 meeting.
Second.
okay, all in favor?
Aye.
Opposed? All right, so
See, we can
unanimous.
agree on something.
All right, back to the agenda.
Planner's plate.
I don't think we have anything, do we, Frieden?
Do we have a
No
planner?
planner?
Right.
Interview yet?
Why can't we just hire this kid for
I
planner?
won't get
Call it
into the
done.
details, but we sent an offer letter to somebody.
You rescinded it after? Oh, okay, so it must have been a background check
Or-
No,
No, one money.
Was he related to me?
So are we still actively searching, or?
We are still actively searching.
Oh, yeah,
The,
yeah.
Posting is still
Yeah.
up.
Same with Blackstone, they're still looking.
Yep, we're still in an agreement with them.
I know we had an agreement with Spencer once, and
Yeah, they went solo.
took one, yeah.
Apparently Spencer had some deeper pockets than we knew.
Of course they do.
Oh, so, do we have any bills that we need to,
Oh,
invoices?
comments on the planner board.
Actually, we got a late one, so it wasn't on the agenda, but it's from Great Engineering for the site visit for mine and Kate.
Okay,
I've not gotten the report yet.
Mr. Chairman, I'll make a motion that we authorize Braden to pay the bill that came in from Graves Engineering for Lyons Estates in the total of $612.57.
Second.
okay, all those in favor?
Aye.
Aye.
Mr. Chairman, if I could go back a moment, in terms of comments from the planning board, I'd just like to wish everyone a happy holiday season. Merry Christmas, if that's appropriate, your situation.
Sure.
And a happy and hopefully safe and prosperous 2026 coming at us like a freight train.
Gotcha. Anybody else have any planning board comments?
Yeah. August 13th, you guys took away my vote, and that lawyer there just told me that my vote doesn't matter anyway, so I'll be taking legal action too, I think.
All right, enough of that. Move on.
All right. Geez, I'm looking at this Graves Engineering invoice. It's got Jasifa Chowdhury on here still.
Really?
Every single invoice he sent.
Does he?
Yes.
Yeah.
Oh.
You know what, make a note, next time, maybe just shoot him an email and say, hey, just,
Yeah.
he must be using an old
He puts her as the mailing address as well.
form. Yeah, nope, that's ancient history. So, because when I first saw it, I was like, what is this, a really old one?
Ask him
And
to,
I was
ask him
like,
to change it to your name at least for now, so that
Yeah,
we know that it's not ancient history.
Just planner.
okay. All right, I guess that's it for comments from the planning board. Nobody left in the audience, so we don't have any comments from the audience. Entertain a motion to adjourn.
Sir,
We
the
gotta.
Oh, hold on.
We gotta,
next year meeting dates.
Oh,
gotta vote on them.
Oh, okay.
Do
So
we have them in here?
With that
Yeah.
calendar that's Braden.
yeah, here it is right here. Give it to you again.
Mr. Chairman, I'll make a motion that we'll adopt the January, or actually 2000, calendar year 2026 scheduled meeting dates that Braden put together here for us, with the, with the understanding that we'll only have a second meeting of the month if necessary, and we'll continue on with our one meeting during the beginning of the months.
Second.
Okay, all those in favor? Aye.
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 Opposed? None. Unanimous.
Motion to adjourn?
You have a motion to adjourn?
Second.
Second, all those in favor?
Aye.
Aye.
Unanimous.